Hello and welcome to the Smart Divorce Podcast. I'm delighted to be joined today by Hollie Orgee from Ampla Finance. Hollie has a distinguished 7-year career as a family lawyer in Birmingham behind her and now expertly bridges the worlds of law and finance. Her invaluable experience and insight now drive partnerships forward at Ampla Finance. So you might remember that we spoke to Nigel of Ampla Finance a few months ago. So if you are interested after listening to Hollie, please go back and listen to that one as well. But we're going to focus particularly today on coercive control and how litigation funding could be an option for people who find themselves in this situation. So welcome, Hollie. Thank you so much for joining me.
Thank you for having me, Tamsin. I think the subject of the podcast today is really, really important for people to understand how financing their divorce proceedings sort of can be done in different ways and really how that can add a benefit to them. So thank you so much for having me.
Oh, it's an absolute pleasure. It's something that we've been talking about a fair bit recently. So we interviewed Matthew and Liz, who host their own podcast from Stow Law a few episodes ago, and they mentioned how litigation finance could possibly be used. And I know you've got some thoughts on the benefits of using litigation funding as opposed to some other methods.
Yeah, absolutely. I think that for most people, litigation funding using a loan to fund divorce proceedings is not something that necessarily is at the forefront of their mind. Mostly, I think, because people don't realise that it exists. Unless you need it and unless you go to a solicitor and you speak about things of this nature, then it's not something that is going to be, at the forefront of people's mind on an everyday basis. But I think that actually it's becoming more and more important to level that playing field, particularly, as you've said, for vulnerable clients, for people who have been in relationships where they have had that control taken away from them in terms of their financial situation. And ultimately, when they then separate from that person, the rug's pulled from underneath them and they find themselves without funds, normally, cut off in very extreme circumstances from any sort of financial support, and finding themselves in a situation where they can't access legal advice, they can't go to a solicitor, or they feel they can't do that because they're not quite sure where that money is going to come from. And litigation funding really provides them with that choice and puts the control back into their hands in a situation where they are going to need legal advice in order to get a settlement from a person who really does not want to engage in those types of conversations, because the whole relationship has been sort of marred by them controlling that position, controlling the finances. And ultimately, when that person leaves that situation, they don't want to give them anything and shut up shop and don't want to engage in that. So I think it's very important that people understand and realise that this is an option for them if they feel there are no other options.
Yeah, absolutely. So if you've got no family that you can borrow money from, you've been cut off from friends, which often happens is in abusive relationships, and especially where there's coercive control, and probably all your forms of finances have been removed, so you don't have access to bank accounts. You've perhaps been given, I want to call it spending money for want of a better phrase, but you've been given a certain amount each month previously, and potentially that's been cut off. Perhaps you've been preventing from working in the past, but as a relationship in the relationship that you've been in the marriage that you've been in, that there's money. You perhaps have a spouse who works, who has a very good job, who's high earning, who drives around in a fancy car, and even though you don't have access to those assets, that there are assets available. And I think that's where this really plays into it plays its hand really, and offers those people some sort of support.
Absolutely, because I think what we see time and time again, and I saw when I was practicing, and I still see now, sadly, is that the person who has control of the finances will often say, "I'm not going to give you money to fight me for my money,"
Yeah.
which, it is an old-fashioned view, because ultimately, where you're married, those are joint assets, regardless of,
Mm.
of who controls the purse strings. But this option, litigation funding, provides that person with the ability to give us a sort of broad spectrum of what the assets are and borrow funds based on what they're likely to achieve at the end of settlement, so that they can go and get that legal advice, so that they can ultimately just get what is fair and reasonable out of the matrimonial pot and what they are entitled to. So it really just puts that control back in their hands. It means that they're not stuck in a situation where the person's saying, "I'm not going to give you any money, you're not entitled to anything." It allows them to actually go seek legal advice, really understand what it is they're entitled to, what it is they're going to achieve. And I think where you're in that situation, it's actually even more important that there's access to this type of funding for those clients, so that they can get proper advice from a solicitor and ultimately, get that outcome that they're entitled to.
Yeah, absolutely. It's, as you said before, it's not the first port of call. It's not the ideal situation for somebody going through divorce, but it's an incredibly valuable option for some people who really need it and don't have other options available to them. So let's get a bit stuck into the nitty gritty. So I'm sat at home, I'm thinking, he's controlling everything. We do have money, but I can't get at it. He's engaging with goodness only knows what lawyers and barristers, and I can't get any legal support myself. Where do I start in terms of looking into the option of litigation finance?
So we are more than available to speak to clients directly. At the first instance, the person doesn't have to have a solicitor to make contact with us, to speak with us, to understand really how litigation funding works. So actually, from our perspective, we're happy for inquiries to come in. We do have a website which provides a lot of information for potential borrowers, even where they don't yet have a solicitor. So they can go online, they can have a look at our fact sheets, they can do an online inquiry where they just put in a few really simple details. We can come back to them and talk them through the process of start to finish, how that would look for them. We can talk to them about what the interest rates would be, talk to them about the process and what we would need to understand in terms of the assets of the parties. And then once they know, or once they have an idea that this is in place, they can then go to a solicitor with the knowledge that actually it's likely I can get this funding. So they can then go and speak to a solicitor, have that first initial appointment, and then the solicitor can then continue and progress that inquiry on their behalf.
Okay. So essentially, they're going to need to apply via a solicitor, but they can get information from you so that they at least know where they stand and whether there's a possibility of being able to achieve this before they go into a solicitor's office.
Absolutely, yes, and we speak to borrowers all the time directly, so that they are empowered really with the knowledge and all of the information that they need to be able to make the best decision for them. Because ultimately, our ethos at Ampla is that the client, the borrower, comes first. So everything that we do, all the decisions that we make, are really geared up to put that person at the forefront, which means being transparent, being fair, being open, and ultimately giving them all of the information that they need to be able to consider whether litigation funding is the right option for them.
Brilliant. And how what's it what's the litigation funding based on? What are you looking at when you're assessing whether somebody is appropriate for this type of funding?
Absolutely. So we really look at the capital assets, so things such as a family home, any other properties that are owned by the parties. And we don't necessarily need the potential borrower to have any assets in their name, which is why it's so perfect for those clients who have been controlled financially by their partner and who potentially have never had even a bank account in their own name because of that coercive and controlling relationship. So we look at the value of those assets, and what we look at is never lending more than 30% of what the borrower is going to achieve as a settlement. And we then do a second check back to make sure that with those funds that the borrower has at the end, once the loan has been repaid and the interest on the loan has been repaid, that they are going to be able to meet their housing needs. So that's either purchasing a property, either mortgage free, or if they've got a mortgage capacity with a mortgage, or making sure that they're going to be able to rent long term and provide themselves with housing. And that's, again, part of our ethos that they really has to be a benefit for that borrower of having this litigation funding in place, of having this finance, because we want to ensure we are really getting them what they need at the end of the process.
Okay. So the marriage needs to have assets. So if you live in a rental property, don't have any savings, this is probably not for you.
No, exactly.
But if you know that there's a family home available, what happens if you think there's money, you live in a big family, large family home, you can see that your spouse is driving around in a particular car, you know that you have annual ski holiday and a summer holiday to Barbados, you live the lifestyle, but you don't know what there is. Where would somebody like that be?
So we can often try and assess a case based on what the client knows.
Right.
We may be slightly more cautious where there hasn't been any sort of financial disclosure, or particularly where the person has been the financially vulnerable party in the marriage. Yeah. And we may look to just release a certain amount of funding in the first instance until the parties have gone through the financial process of disclosing the assets to each other in the normal way, either in a voluntary process or through the court proceedings, so that hopefully more information is then gathered about the assets, and we can then look to reassess whether there are the assets there that the borrower thought there were, and whether that loan still works for them.
Okay. Oh, so it's not a one-off, like this is the amount we're prepared to give you and that's that. It could be reassessed later on in the process. So if it came to it and there were much more assets than you ever thought once disclosure had been done, there's the potential that further borrowing could be available.
Yeah, exactly. So in some circumstances, we're able to extend borrowing for clients because the asset base is larger than was first thought. We just want to ensure when we're looking and making those assessments that we are not overextending for the borrower, because we want to ensure that they are getting what they think they're going to get at the end of the process. So yes, there is always the option of extending where financial disclosure hasn't been exchanged between the parties, where one person is still slightly uncertain about what there is. We will take a far more cautious approach to ensure that they are not sitting with a big debt that they couldn't service if the assets aren't what they thought they were at the outset.
That makes sense. I guess I'm thinking about it, and I know a little bit about litigation funding, but what we haven't explained is actually what it is.
Absolutely.
I think we should do that. So
absolutely. So in terms of litigation funding or litigation finance, we are able to offer loans to clients who are going through divorce proceedings to pay their legal costs, whether that's solicitors' fees, barristers' fees, any other costs that are associated with the process of getting to a financial settlement. And that could include paying for experts' fees. So if there needs to be an accountant, if there needs to be somebody to value your property, we're able to fund for all of those elements. We can also fund for children matters. So if there is a dispute in relation to the arrangements for the children, we're able to fund for those as well if there is an ongoing financial case as well.
Yeah.
And there are other matters that we can fund as well, such as sometimes we're able to look at funding for cohabitees. Those are in sort of more limited circumstances, but we're able to consider different types of funding where the ultimate umbrella is sort of family issues.
Okay. And is litigation funding only available for the court process, or is it available for non-court dispute resolution as well?
So we are able to fund for mediation, private FDRs, and also arbitration. So I think it's really important that people understand that they don't have to go through the court process. And I think that's something probably that solicitors say to clients all the time, is that actually there are different options for them in terms of progressing and pursuing a settlement. So our funding is available for parties going through arbitration, which is a much more condensed process, and actually is where litigation funding is really important, I think, for those types of clients who don't necessarily want to get caught in the long court process. Even where clients are in the court process but actually want to explore that alternative way of resolving issues, we are able to fund for those as well. We just want to ensure when we're looking at those alternative ways of funding that if, for example, the private FDR or mediation broke down and a settlement or an agreement couldn't be reached, that we could ensure we could fund to a final hearing to make sure that we're getting the borrower to a final outcome rather than them being sort of stuck if the alternative route doesn't come to fruition, that they're stuck then without having any options. We want to make sure that we can cover those scenarios.
Okay, that's interesting. So I obviously have a question. So how do you do that? How do you, because going the cost, from my understanding, of going through the court process to a final hearing is eye-watering, or can be eye-watering. So, and arbitration is not a low-cost process. So to ensure there's enough to go through the entire court process as well as arbitration, that's presumably a significant sum.
So in terms of arbitration, it's slightly different because arbitration results in a binding outcome.
Oh, of course.
So for arbitration, we don't necessarily need to be concerned about that process not working out, but more in terms of mediation and the private FDR process, we want to ensure that if the private FDR didn't result in an outcome, and when the parties then fall back into the normal court process, and I say normal in sort of inverted commas, when they fall back into that court process, that we can continue to fund that case if they do need to then go to a final hearing. Arbitration, because of the binding nature of the award, we can fund that process in its entirety. We would just talk to the solicitor and the client about the possibility of an appeal and whether or not there may need to be some further costs considered in that scenario. But actually, the arbitration process and the court process are very similar, apart from the fact that in arbitration, the parties have much more control over the process, and funding in that way means that it gives them a fund to choose their judge, choose where they go through their arbitration, if they want to do it at a nice hotel, if they want to do it in a country manner, that they can choose where they go through that process, which for some people, actually, because the costs are sort of spent in a very short period of time, that's not a reality for some people because they just don't know where they're going to get that money from to pay for all of those things. But actually, litigation funding and financing the proceedings in that way gives them that pot of money to draw on when they need to, And actually, arbitration is normally concluded much more quickly than the court process, and much more bespoke. And for clients who, don't want to be questioned, for clients that don't want to stand up in court and have to talk, the arbitration process is completely bespoke, completely customizable to however the parties want to go through that process. So for me, funding for arbitration really gives clients an option, and sometimes can get better results.
Are you saying this has nothing to do with litigation funding, but I'm just interested? So, are you seeing more and more people using arbitration? I know, obviously, no, you're no longer a family solicitor because you're at Ampla, but are Ampla finding that they're funding for arbitration much more?
I think not at the moment, because I do think that there is still a sort of focus and a fallback on the court process because it's familiar to people,
Yeah,
and arbitration is unfamiliar to a lot of people, and it is sort of something that clients are either very on board with or is quite scary to them. And I
yeah,
think that is because where litigation funding hasn't necessarily been considered, it is a lot of money to find in a very short space of time. So
sure.
actually the court process sort of, I guess, elongates the time over which you're having to pay, which means you have to pay as much each month. And there's sort of a false economy to that. But I guess it's a known entity. It's a known process. It's, as I said, familiar to people. But where I'm going out and speaking with solicitors, where I'm speaking to borrowers, I do always talk about using funding in that alternative dispute resolution to follow a different process,
Yeah,
especially given the court delays and the fact that most people are going to be in that process for a long time. It's very, very stressful.
yeah,
So I hope that we will start to see a bit of a shift and more solicitors coming to us to talk about alternative ways of progressing family matters to settlement.
yeah. No, I'm absolutely with you. Some of the court delays that I've heard recently are eye-watering. Um,
Absolutely.
what's so we've talked about the borrowing end.
Yes.
What about the paying back end? How does that work?
So every borrower pays their loan back at the end of the proceedings once any order that has either been negotiated between the parties and agreed or set down by the court, once that's been implemented, and that will often result in either the sale of a property, so the sale of the family home, or a lump sum being paid to the borrower, then they repay us once that's come to fruition. So there's no repayments prior to that point. They don't have to make any monthly contributions to the loan. They can if they want to, but it's absolutely not necessary. And actually, the majority of borrowers don't do that. So we will have repayment once the family home is sold or any other property is sold, or once the client, the borrower, has received a lump sum payment to them, which means that unfortunately we can't lend if there's going to be a deferred sale of a property. So if there are small children, if the property's not going to be sold immediately, we can't lend in those situations, because for the borrower it would mean interest running for, who knows, it could be a
Yes.
number of years, which is just
Yeah,
not in their best interest.
sure. Oh, that makes sense. So, so it's not a case that the settlement's sealed by the court, sent to the borrower, and then suddenly the borrower's got to find all of the money because there's a piece of paper saying what they're going to get. It's literally it's once the money's in their hands before they have to pay that back.
Exactly. And ultimately, we work with the borrower at that point, which we know there's been a settlement, to make sure that the time frames are understood by us, so we know when repayment's going to be, so that we know how they're getting on with the sale of a property. So we make sure that we have those touch points with the borrower to ensure that the repayment is made, and they can then go and purchase their property, or go and find a rental property, and do what it is they need to do with those funds.
Brilliant. I like that. That's good. That makes a lot of sense. And something that I want to come back to that I forgot to ask you before is about it's about independent legal advice. So because the litigation funding is arranged through a solicitor, I understand that you recommend that they take independent legal advice regarding the borrowing. Could you just explain a little bit about why and what that process looks like as well?
Yeah, of course. I think for us, and particularly from a financial services perspective, it's really important that every borrower properly understands the process that they're entering into, the documentation behind that sits behind the loan, so the credit agreement that they will be signing up to, understands the obligation on them and any conditions on the loan. So every borrower, where a loan offer is made and they accept that offer, has to take independent legal advice. And that's to ensure that they are not being sort of forced into taking that borrowing, that they fully understand what they're signing up to. So at the point at which they accept the loan offer, they can either use our panel solicitor to take the independent legal advice, or they can go and find their own solicitor. If they've already got somebody in mind, they can go to that person who will then hopefully go through the process. We'll talk to them about the risks of taking this type of loan. We'll talk to them about, as I said, the obligations, and really make sure that they fully understand what they're signing before they take the loan.
Okay, I didn't know you had a panel. That's great. So the independent person that they're talking to, are they also a family solicitor or are they a different type of solicitor?
Yeah, absolutely. They're a different type of solicitor. They're not a family solicitor. They're a solicitor who ultimately is able to explain the process of taking the loan and the financial risks and elements to that
Right.
process to the client.
Oh, okay. I don't know that either. There you go. I'm learning loads today. This is great. um, we're probably coming towards the end of our conversation today. Is there anything that I should have asked you that I haven't?
No, I don't think so. I think that for most people, litigation funding is not going to be something that is suitable for everybody, that it should be taken by every single person. It's not something that we would advocate is a product that, every person getting divorced should use. But I think there's most definitely a place for litigation finance in the divorce sort of area to really level the playing field for clients who potentially don't have any other options, to make sure that there's a quality of legal advice between parties, which really ensures that those clients who are most vulnerable and probably coming out of a situation which is, the worst time of their life, have the ability to take legal advice, which for some people is going to be the most important thing that they can do to ensure that they get a fair outcome. So for me, and going to speak to solicitors, it's very important that borrowers know that we exist, can understand the benefits of having legal advice, to know that ultimately we are here to help in those types of situations. And ultimately, we hope that that gets the borrower a better outcome, or an outcome at all, because had they not had that fund to take legal advice, they may have just had to walk away from what could have been a long marriage. And, ultimately that doesn't have any element of fairness to it.
Absolutely. That's a great note to end on. Totally agree with that. Hollie, thank you so much for joining me today. It's been brilliant to talk to you, and I have learned a huge amount. I'm sure our audience have as well. Thank you for joining us today, and we'll see you on the next episode.
Thank you.